Lordship, I'd like to mention item number 5. That the leading counsel N. Rama is out of station. Therefore, matter may be listed after 2 weeks.
Item number 5, N. Rama is out of station.
Yes.
Why I saw him in the morning today? Why did I see
Sorry.
him in the morning in that court?
No, it's N. Rama, my senior.
Oh, N. Rama.
Yes.
Oh, N. Rama.
Yes.
Learned counsel, Mr. N. Rama is out of station. Item number 5.
5.
Heard Mr. D. Tamu, learned counsel for the respondent. List the matter after. When do you want?
2 weeks.
2 weeks. List the matter after 2 weeks.
Obliged.
I beg to miss item number 7.
7.
Yes, my lord, lordship, kindly let the matter come, then we will decide on that. Right,
My lord, in this case, I will file affidavit in opposition.
on the last day, there was interim, last day it was vacated, so let the matter come.
I will file affidavit in opposition in this case. So I may be allowed 2 weeks then, only 2 weeks, sir. To file.
Kindly, matter, may be- let the matter come, because
Okay,
my
list the
senior
matter
has to
come
appear.
in a series. Okay, we'll start from 2 then. We'll
Obliged.
turn by turn, we'll come to you.
My question, because this is a joint petition. Your lordship, here it's on settlement ground. Both the parties has already settled. This is related to your lordship, Nagaland PS case. Nagaland PS case.
439,
Yes, lordship.
384, 506.
384 and 506. 506 is compoundable. 384 is extortion. It's non-compound. Lordship, here this brief story is that your lordship, the nephew of the victim, there was a minor collision in scooty collision. So the accused was asking for money, and though the amount of damages was very less, he was repeatedly asking for money. For that reason, he has filed the complaint, and extortion was the section of extortion was implicated later on. Your lordship, here it was all a misunderstanding, and they have already settled the matter. Lordship, when the trial is on appearance stage, it's no, all the charge sheet has I have already filed. There's no subsequent development on it.
This is a deed of agreement,
Yes,
marked as annexure
marks as annexure
3.
3, page number 38.
Okay, let me hear the procedure. Yes.
Yes, your lordship, LCR may be called for in this regard, your lordship. It's a matter of 2017, your lordship.
It's still in appearance station.
Where is the order?
Order and appearance में गया नहीं होगा.
In that case, LCR may be called for fixing this matter on Monday, your lordship, coming Monday.
We'll call for the scan copies of the LCM.
Yes, your lordship.
All right. Heard Mr.
T Gyatso.
T.
Gyatso.
Gyatso, learned counsel for the petitioner, and Ms. T. Ginny, learned additional PP for respondent number 1. One respondent, sole respondent.
The respondent sole response.
This is the joint petition, your lordship.
Accused and complainant together. For the respondent, state of Arunachal Pradesh. And the post of the learned additional PP has accepted notice on behalf of the respondent, so no formal notice is required to be issued to the respondent. We'll call for scan copies of the LCR. List their petition has been filed jointly by both the parties. List the matter on Monday.
24.
Thursday. This
20.
Thursday, 20,
It's in this code only, UPI code only.
this Thursday,
Yes, sir.
tomorrow,
On the day after tomorrow,
day after
20.
tomorrow, okay. This is the matter of Thursday, this time, 20th.
Deeply appreciated.
Obliged.
May your lordship.
Lordship, it's a joint petition filed under section 4H2 of CR50 for passing of charge number so and so corresponding to income PSK number so and so register under DR case number so and so.
Is the joint petition?
Yes, your lordship, there has been settlement between the parties and the parties, both the parties, they are related to each other as father and son, your lordship.
Father and son?
Yes, father and son. So may I take you to the brief, your lordship?
Hmm.
So the brief peg of the case leading to the filing of this instant petition is that FIR dated so and so was filed by the petition number 1 against the petition number 2 because of some misunderstanding in connection to their family property, which lead to some verbal altercation and some minor skirmish. And thereafter, since both the petitioner, they are still living together under same roof, they have decided to settle the matter in amicably so as to live in harmony, your lordship. So may I take you to the your lordship, may I take you to the deed of agreement? It's on annexure number 3 and page number 56.
This case was charge sheeted?
Yes, your lordship, it has been charge sheeted and it's under section 324 of IPC.
324.
Yes, your lordship. The petitioner number 1 is no longer intending to pursue the matter, your lordship. And since the petition number 2, he is taking care of petition number 1. He is a old age man, your lordship. Because of some misunderstanding only, he have lost the FIR.
This was the deed of agreement?
It's page number 56, annexure number 3, your lordship.
55.
Oh, 55 years, sorry, your lordship, 55. May I read the deed of agreement?
Not required, I have time already.
Oh.
Going through it.
Yes. This has been executed before executive magistrate.
Yes.
Yes, your lordship. Your lordship can dispose of this matter at this motion stage itself, your lordship. Otherwise, also the charge sheet was very recently being filed, your lordship. Also, since both of them are father and son duo and staying in the same house, your lordship. Lordship.
Hope he
And even the
doesn't
charges.
carry on with his activities.
Yes.
No, your lordship. He has seek forgiveness from the petition number 1, your lordship. He's an old age man and he's 80 years of age, so
324.
324, and he has the injury, it was simple. And the
324 simple is not very simple.
yes,
It's
but
a
the
minor
as per the medical report, it's as per the medical report, the injury he has sustained is of simple nature.
Yes, I will dispose it of, but ask him to behave.
Yes, your lord.
I'll dispose it of, no problem. Art Miss
A talon, M talon,
M Talon, item number?
item number 14, your lordship.
So your name is not in the.
It's in the post.
M Talon?
A talon, A talon.
Oh, Amy Talon.
Yes, your lordship.
Third Miss A Talon, the counsel for the petitioners,
Yes.
so and so. And Miss T Ginny, the petition PP for the respondent. State of Arunachal Pradesh, full stop. Both the petitioners. Sri Tanyo Lipi and Sri Kadamli Pir have jointly filed this petition under section 482 CRPC with prayer for quashing and setting aside the charge sheet number 32/22 dated 26/9/2022 in connection with Inkyo PS case number 27/22, registered as GR case number 30/22 under section 324 IPC. It is submitted that both the petitioners have been, father and son have amicably settled their dispute. Who so they are living in the same household. Most of the son has asked for forgiveness for his act as alleged in the FIR. Post of Shashik was laid against the petitioner under section 324, petitioner number 2 under section 324 IPC. The son at present is taking care of his 80-year-old father, who is the complainant. Full stop. They have amicably settled their dispute and the deed of agreed settlement executed before the executive magistrate is appended along with this petition and marked as annexure 3. I peruse the deed of settlement, the copy of the FIR marked as annexure 1.
Annexure 3, Your Lordship.
Annexure 3 and the charge sheet, copy of the charge sheet marked as annexure.
2, annexure 2 series.
As both the parties are staying together in the same household and as both the parties and as the dispute is predominantly private in nature, I deem it a fit case to invoke the inherent jurisdiction of the section 482 CRPC. Full stop. Possibility of conviction appears to be remote and bleak. Full stop. At present, the son is taking care of his 80-year-old father. To the agreement, both the parties have pledged to stay peace, to maintain peace and stay together peacefully and harmoniously in the same household. In view of the foregoing discussions, petition is in view of the charge sheet number so and so is hereby set aside and quashed.
Highly of-
Lordship, I pray for adjournment. Senior counsel is out of station and he already filed absence letter.
Morik Bagra.
Yes,
Legal
ma'am.
counsel Morik Bagra is out of, M Bagra is out of station. List the matter on
Next month, Lordship.
next month.
If possible, 1st of August.
1st of August. Date, should I give a date?
It's 1st of August, Your Lordship. 1st of August.
Replay.
Much obliged.
Lordship, this bail application was partially moved on 27th.
Is a criminal case, FIR case, and which was filed Port of Quasi under section 482. So the Honorable High Court may please to direct the police, concerned police authority that the actual procedure through the service copy of the petition copy may be served to the police.
That police.
Concern,
concerned police.
yes, concern police. Yes, yes.
Serve the
He
notice.
wants to take a step to the concern OSIP.
Mm.
Yes, of the concern jurisdiction.
Earlier, justice service was permitted, but
Yes,
He did
yes.
not serve the purpose.
He didn't, it didn't serve the purpose. He declined to appear. So as per the provision, the latest. The final attempt and completion of the service may be done through police council. That is Bandura PS. The FIR was lower than the Bandura PS, so Bandura PS may be directed
Bandara, yes.
Bandura PS.
Heard Mr.
M Nibo,
M. Rebo.
M Nibo. Item number 15, my lord.
M. Nebo, learned counsel for the petitioners. And Miss Lakshmi Hage, learned additional PP for the state of Arunachal Pradesh. Full stop. Notices were issued to respondent number 2. To Dusty Service. But they have refused to accept the notice.
Yes, yes.
So
Decline.
when notices refused to be accepted, then it is deemed to be served actually.
But then as per the provision, because this is connected with this criminal case, so police may be given a last opportunity so that we may exhaust all the possibility of service. So Bandura PS may be given.
Lordship, this time Lordship, the through OCPS is directed to serve the notice upon respondent number 2.
Where is it given that they have refused to accept the notice?
That is on the 16/5/2023. The notice was given and I have filed the same order.
15/5/2023.
Yes. Dusty order was dated 16/5/2023.
Dusty order. That it is in the or the office note that they have refused to accept notice.
Yes, I had already filed the affidavit in the
Affidavit.
form. Yes,
It is in the affidavit.
yes, yes. It's the affidavit.
I'll see the affidavit. In which paragraph the affidavit? Seen the affidavit regarding relating to service of notice to respondent number 2, Dusty Service.
This service was taken by our registry Lordship. This service was taken by our registry Lordship.
But the affidavit is filed by
By
the petitioner.
by the petitioner.
It is mentioned in the affidavit that the respondent number 2 has refused to accept the notice, stating that he is no longer junior engineer, but he is serving as assistant engineer.
In some other place.
Uh,
Yes, the government servant, they keep transferring. So by that time he was at the Bandura 5/1.
So
PWD.
he is the same person. So
Yes,
if
yes,
he-
same person, same
if he has
person.
refused, then
Yes, yes,
it is deemed to be served.
yes, my lord, that is what I presume, but The
Lordship,
letter was.
his fear is that, Lordship, earlier the justice service was not being served upon him, so this time best step
No,
may be taken
The
upon
petitioner
him
has
to
further
the
prayed,
arrest, yes.
The petitioner has further prayed to issue notice to the respondent number 2 through the jurisdictional police station.
Yes,
The petitioner is allowed to take fresh steps through the jurisdictional police station. However, it is noted that the respondent number 2 has also refused to accept notice. So later on, anybody can pass an order that it is due to be served.
my lord, next day.
List the matter on
After a week, next Tuesday, will.
next Tuesday.
Yeah.
Will it be possible? I don't think so. Next
Because
Tuesday. Patodua.
residence is at his personal residence is at Duimu and Pandadua PS, we can easily, it's a matter of one day to concern.
Yes.
So if I, so let the next matter be next
Tuesday.
Wednesday. Wednesday matter, Tuesday,
Next
Wednesday.
Tuesday, Wednesday.
Wednesday also,
Next Wednesday, date please, Jana. 26. All right.
most obliged.
If I may, your lordship, on the last occasion, we have taken a step upon all the respondents. And then it seems the service report is still awaited.
Service report
Yes.
is available.
I am referring all the respondents. There are 3 private respondents. I am representing all the respondents. And today only I have filed the Bakalatnama.
So service is
So,
Yeah,
complete then.
Okay,
so I need some time, 3
3
weeks time.
You need 3 weeks time.
Yes.
Learned counsel for the petitioner, Mr.
J3,
Huh?
J3.
J. Sering.
Yes.
Item number 5, Nikki.
4.
J. Sering
Yes, your lordship.
is present.
Entaje.
Learned counsel, Mr.
Entaje.
N. Tajir is present on behalf of this civil division.
All the respondents. 3 respondents.
Yes.
Present on behalf of all the 5,
3
Three
respondents.
all the 3 respondents.
Yes.
We have only 3 respondents.
Yes, your lordship.
Is present on behalf of all the respondents, full stop. The lawyer counsel for a respondent has paid for 3 weeks time.
Time
For
to file objection.
to file objection.
Yes,
The matter after 3 weeks.
after trigger. Obligement.
Yes.
May I please, Lord?
Mm,
Lordship, this is a civil revision petition
mm.
under 115 of CPC.
My lord, in this,
Oh,
I am
so-
short time to file affidavit in
Hmm.
opposition. So I may be allowed 2 weeks time, only 2 weeks time.
Lordship, on
He
the,
was insisting, from-
Lordship, this particular matter, initially, this was moved on 19 June. And thereafter, interim was granted to the petitioner and subsequently, it was taken up on 12th of this month. And then unfortunately, I was not there. However, this honorable court was pleased to vacate the stay order, initial stay order pass. And then in fact, this matter was in fact listed, fixed today for disposal, Lordship. So Lordship, if Lordship may allow, then Lordship may hear the matter.
but he's praying for time to file, give him a short date.
Lordship,
So 1 week maybe.
Lordship,
One-
the issue
one
is
week.
even tomorrow, the matter is fixed
Hmm.
for, it is in the evidence stage.
Hmm.
Basically, the matter is with regards to land dispute, Lordship.
You pray for adjournment tomorrow.
Tomorrow, Lordship, initially on 12th of this month, it was listed, and then it was fixed on 19. So this particular matter is.
So already stay was granted, then again it was vacated, so
Vacated.
I'll not grant stay again.
Yes.
I'll just mention, bring it on record that you apply for adjournment tomorrow. As this
Yes.
matter is pending.
Yes,
So
Your
let us allow
Honor.
him time for. And then thereafter you won't be given time.
Yes. even as my lord, this revision petition is maintainable. This revision petition is not maintainable.
But that will come up for final argument
Yes.
after your objection. So you file objection within 1 week,
Yes.
1 week,
Yes,
or
sir.
you want shorter time?
1 week,
One-
fixed date may be given.
Yes, fixed
Your
date.
Lordship.
So you, I'll bring it on record regarding your. You pray for adjournment tomorrow. Heard, Mr.
Eighth of that.
A. Tata, learned counsel for the petitioner, and Mr.
Oh, Modi,
O.
Modi.
O. Modi, learned counsel for the respondent, who stop. The learned counsel for the respondent has prayed for time to file affidavit. The post of the learned counsel for the petitioner has raised serious objections stating that the matter is fixed for evidence tomorrow in the trial court.
Yes, sir.
He unfortunately, it is also submitted by the learned counsel for the petitioner. That unfortunately, due to his absence on 12/7/23, the order of stay of the proceedings was vacated. Considering the
My lord,
submissions.
on last occasion, counsel for the petitioner present, not absent.
Since I'm the
He may be
conduct,
absent, but
I am-
was present.
I am the conducting counsel in this particular matter, and in fact, it was
You're
we-
present or not present?
I was not present, your
It's
lordship.
not
I
present.
was not present,
This is
and
what he
then,
has submitted, this is what I have recorded.
yes, I was not present, and then.
Considering the
in fact, we
submissions
saw the-
of both the sides, the learned counsel for the petitioner may apply for adjournment before the trial court for 1 date. And the respondent is given time only of 1 week to file his objection, and the matter may come up for final hearing thereafter. Post of. List the matter on
26,
26,
yes, lordship.
26.
Deeply ordered.
In item number 11, your lordship, the amicus who was appointed, your lordship, learned counsel, Mr. Ninong Ratan, he has been appointed as an additional AG, your lordship. So, your lordship may kindly appoint any other amicus, your lordship.
Oh,
We'll
what,
we'll have to recuse from this.
so he is appointed as
Additional AG, your lordship.
additional AG now.
So any other amicus curiae may be appointed.
Where is he will appoint?
Yes, yes.
The learned amicus curiae, Mr. N. Ratan. His name? Or Mr. N. Ratan has been appointed as additional AG.
Additional AG.
Additional AG, registry to appoint any other amicus curiae to represent the appellant, jail appeal.
Yes.
Hard Ms. T. Lee, learned additional curiae for state of Arunachal Pradesh. This the matter after 3 weeks, 3 weeks, not required, not more time.
Yes. Your lordship, if I may, your lordship, in item number 3, your lordship, that your lordship has heard section 8 of the POCSO Act, your lordship. The since the registry also will have to, along with the LCR, will have to forward the order of this honorable court, your lordship. However, in which court and the case number of that POCSO case has not been reflected, your lordship.
Trial, I have written trial court.
Yes, your lordship. Now,
It will be trial that, it is not a court of committal. So in this, doing investigation, that, trial court also, the trial court is the court. Intermediary court.
yes, your lordship. Now, what my prayer before your lordship was that in the order, your lordship, if that line, that however the case number and the court before which, because the jurisdiction of the court before which it is pending has not been reflected. The learned counsel may subsequently submit the case number, your lordship. I'll inform the council.
You want
Because-
a line to be included?
Yes, yes, because that will be, that will be a problem even for the registry, your lordship, because registry have to, even on the last occasion, since the forward, because of the case number was not given, the registry could not forward, and therefore the case where stay was granted, the court did not stay the matter, and subsequently they came for So those problems, Your Lordship. I'll inform the councils
Yes,
too.
these numbers are, figures are very
Yes,
important.
yes, because
Case
they-
number, sessions case number,
Yes,
are
yes.
very important.
Yes, Your Lordship. I'll inform the learned council too, Your
Yes.
Lordship. The-
Oh, you include it? She has given the dictation, no? You can start, then we'll continue after lunch also. And if you conclude before lunch, then nothing like it.
I think I won't take much more than 10 minutes.
That is very good.
Appeal against the conviction order passed by the Session Court Honsayon, whereby I was sentenced to undergo imprisonment under section 25
I'm sad.
Arms Act,
And he, yes,
convict Tyler is sentenced for undergoing rigorous imprisonment for 3 years under section 348 IPC. He is sentenced for 10 years rigorous imprisonment and payment of fine of rupees 20,000 for the offense under section 25(1)(a) of Arms Act for the offense of possessing prohibited arms and ammunition in violation of section 7 of the Act. His further sentence to undergo 10 years rigorous imprisonment and payment of fine of rupees 20,000 for the offense under section 5(a) of the Explosive Substance Act for the offense of possessing grenades and detonators in default of payment of fine. The convict is to undergo additional 2 months simple imprisonment, which this court find fit to serve the purpose of justice. The sentence are to run concurrently. The case is like that. The FIR was lodged on the FIR is in page number 33. So
date cannot, date has been, that is hidden under the seal.
see, this is
Sometime
13.
in September 2019.
Yes, 13th September to 2019. May I read the FIR?
Yes, yes.
This is applications to lost to the officer. It is application to lodge FIR against active hardcore insurgent of NSCN KYA apprehended on 13th September 2019 from village Lokhau, district Longding. Based on a credible input received from the source regarding presence of Naga Army number this SS Colonel Tailai Wansu, along with 4 or 5 other insurgents of his group in village Longhau, district Longding, an operation was launched by this battalion on 12 September 2019 in general area Longhau, district Longding, wherein SS Colonel Tailai Wanchu and SS Alwa Wanghan of NSN KYA have been apprehended while trying to escape from ongoing firefights with security force. The search operation was started at 00:45 hours on 13 September 2019 in the village Longhau. At about 2:30 hours on 13 September, our troops were fired upon by insurgents from a distant location. Our troops immediately divided themselves into 2 parts, while one column put a block onto Longhau Pakwa track. The other was engaged into firefight with the insurgents. During ongoing firefights, one of our Jawan, Seth Satnam Singh, received a bullet hit on plate number this, make this, of his bulletproof jacket. Bullet got stuck in BPJ, and so life of the soldier was saved. SS Colonel Tailai Wangsu and SS Alwa Wanghan tried to escape towards Bakwa, Nagaland, where they were intercepted by our party on Longhau track and apprehended them armed with arms and ammunition at about 2:40 hours on 13 September. Details of recovery, arms and ammunition, other articles is as below, which are handed over to the police herewith. So he had mentioned 9mm pistol, 1 number, live round 9mm for mentioned pistol, 13 numbers, and grenades 2 type, 4 detonator 3, appointments stamp of Rajapayo GPN, extortion receipt paid along with record of extortion collected previously from various village for rupees. This village was detail of collection extortion is enclosed separately. During interrogations, following informations were revealed by both the cadres. SS Colonel Tailai Wangsu revealed that he had joined NSCN-K
in 2004. He got his military training in Taga camp at Myanmar. He was operating from Myanmar and had handed over the extortion money and also referenced his emanations. Both the cadre revealed that on 11th April 2019, on the day of general and assembly election, he along with Botai Wangshu, Palai Wangsu and 5 others cadres carried out firing in village Langkau to instill fear into common people against using their right to vote. He also revealed that he was actively involved in sending extortions demand and threatening to villages for daring consequences if demand was not fulfilled. He revealed that the collected extortion money was sent to SS Colonel Bopa Wang Nao, either by himself or through common civilians. Both the cadres revealed that they were using route.
So this is in which part of Arunachal Pradesh?
This is in the Longding part, in the easternmost part, bordering Nagaland and Assam towards the Soraido district.
Oh, that part of.
Yes,
So near Sunari.
near Sunari. They just,
Nagaland, Assam.
yes, next to Sunari.
Lohit district,
Longding,
Longding.
Longding.
Near Lohit maybe.
No, Lohit
Tira.
is Lohit, Tira.
Tira
It was before undivided Tira, part of undivided Tira. Lohit is in the eastern side,
Or this side,
Tinsukia,
no?
Tinsukia.
Near Tinsukia side.
So they had recovered and they had handed over this. FIR was filed and accordingly, a case was registered under the Wako police station under section 384 IPC 25(1)B of Arms Act 9(b)(2) in Explosive Act and sections 10 and 13 of the UAP Act because no sanction was there. Accordingly,
No sanction?
for UAP, arms and explosive, there is.
They have a
sanction.
sanction, but no sanction for UAP.
UAP. So accordingly, UAP Act, that section was dropped. And accordingly, the charge
So
after,
charges under UAP Act was dropped.
yes. Charge sheet was filed after completion of investigation. So on the basis of the material available in the charge sheet, the court has framed charges.
Yes.
Charge sheets was filed. Along with the charge sheet, they had filed CJ memo. May I come to CJ memo?
CD,
Uh,
CDR.
yes, CJ memo. It's in page number 68. The type copy is in 69. CJ memo. Page 68 is the handwritten part and 69 is the type copy.
69 CDR member.
CJ memo. Here it is clearly mentioned date and time of seizure 13/9/2019 at 2200 hours. Place of seizure, police station, Longding. Case reference is given. Is J. Wangsu do hereby seize below mentions.
Where is the date?
Date is 13/9.
Where?
Date is in the top. Page number
59,
13.
page number 59.
It's 68.
Oh, 68. Oh, yes. Yes, seizure memo.
Do we hereby seize the below mentioned articles connected with above referred case of the below on being produced. On being produced by Naik Subedar H. Singh. It was not seized from the possession of the appellant. Your Honor. And here two seizure witnesses there, Constable L. Tikhat and Sri P. Singh of 9-6 Regiment, and one is from OCPS Longding. On the basis of charge sheets and the material available in the before the court had framed charges with 3 heads on 3rd February 2021. This is in page number 84.
84.
84. Madam. Charged with 3 heads. Number 1, I say this district judge and session judge Tirap, Longding, Chanlan, this is just is resident of this is hereby charged you Tailai Wangsu, number long Wangsu, resident of this, firstly, that you commit extortion and thereby committed an offense punishable under section 384 of the Indian Penal Code with the cognizance of this court of session. And I hereby direct that you be tried by this court on the said charge. Secondly, that you possess one 9 mm Golok pistol with magazines and 13 live ammunitions are prohibited arms and ammunitions and thereby committed an offense punishable under section 25(1)(a) of the Arms Act with the cognizance of this court of session. And I hereby direct that you be tried by this court on the said charge. Thirdly, that you fired upon one defense personnel which for the case of the constable Satnam Singh thereby committed an offense punishable under section 27(2) of the Arms Act with the cognizance of this court of session. I hereby direct that you be tried by this court on the said charges. The charges are read over and explained to the accused persons to which pleaded not guilty and claimed to be tried.
Later on, he was charged under the explosive substances.
Yes,
Act,
again, it was charged after conclusion of the evidence, both prosecution and examination of the accused under 313. Again, a charge with one head was framed. And that was framed on dated 2nd September 2021. May I read that? This that you possess explosive substance which is prohibited and thereby committed an offense punishable under section 5(a) of the Explosive Substance Act 1908 within the cognizance of this court of session. And I hereby direct that you be tried by this court on the said charge. The charge is read over and explained to the accused person to which he has pleaded not guilty and claimed to be tried. This is important date, Your Honor, because this is after framing of these charges, neither the prosecution has produced any witness to prove these charges against the accused, nor the court had said anything why they had not provided an opportunity to the defense or to the appellant to cross-examine to disprove the case in this aspect, Your Honor, because straightway the judgment was passed. May I read? For this, they had examined 4 witnesses, Your Honor, prosecution witness.
All right.
To prove the charges against the appellant, the prosecution has examined 4 witnesses. It's in page number 86, Your Honor. May I read the depositions? PW1 is the complainant, informant. On 13th September, during midnight, operation was taken place at Langkau village near Ponchau for nabbing NSCN miscreant. I was not a member of the operation group. This is very important. Alpha Company of 19th Sikh Regiment conducted the operation. And during the operation, the troop has apprehended 2 miscreants. One Tailai Wansu, SS Colonel of NSCN KY, was apprehended along with another Alu Wang Nao, SS Colonel. During the time of apprehensions, 9 mm Glock pistols made in Austria with 1 magazines and 13 live rounds, 4 hand grenades, 3 detonators, 1 stamp of NSCN organizations, and 1 receipt book used for money collections. After apprehension of the miscreant with above arms and explosions, they were taken to battalion headquarters at Punjab, and thereafter they are taken to our head office, Longding. I was commanded by my controlling officers to hand over the accused person with recovered arms and explosions to the police station. Accordingly, I have taken the accused person to hospital for their medical checkup, and I have handed over the accused along with arms and explosions to the officer in charge of the Longding police stations. I have also filed a written FIR before the officer in charge during the time of operation. While apprehending the accused person, the accused fired upon the troop and 1 sepoy, Satnam Singh, sustained bullet injury. But the bullet stuck on the bulletproof plate of Satnam Singh, and he has not sustained major injury. The accused person standing on the dock is identified as one of the accused person, which is apprehended by me. He had exhibited 3 documents. Exhibit number 1 is the FIR lodged by me. 1 is my signatures. Exhibit 2 are photographs, seized material. Exhibit number 3 is the CJ memo, the arms and explosions, and is my signatures. In cross, he says, it is a fact that I was not present during the time of cross examination. It should have been cross firing. That's mistyped. I have not seen during the time of recovery of arms and explosion from the possession of accused, Your Honor. He is not an eyewitness of the recovery of the this arms and explosives. We have not found any identity card from the possession of the accused showing that he is a member of NSC and K1. I have no proof so that the accused had fired upon Satnam Singh. The incident took place during night. It is not a fact that NSC and personnel who were there during the operation and fled away and troops had apprehended innocent. We have not investigated into the case. After apprehension of the accused, we had forwarded to the police. It is proved that he was not an eyewitness to any of the arms and ammunition or anything what was mentioned in the CJ memo. And the prosecution has examined again PW2, the Satnam Singh who had sustained injury. This on 12 September, we have launched one search operation at about 11 p.m. We went from the Panchal COBC and proceed towards Langkaw. It took about 1.5 hours to reach Langkaw. At about 12:30, we arrived at the place of operation. One of our parties was behind us, and I was a member of the forward team. It was night and there was drought. We searched on the place of operation on foot. At about 2:30 a.m., I have heard firing sound from front side. Bullet hit my chest and I fell down on the ground. I had also fired few rounds, but I was afraid. My company commander came near me and asked me to whether I am okay. I have checked that the bullet hit on the bulletproof plate and stuck there, and I have not injured by the bullet. As I sustained a hit on my chest and I was afraid of my company commander, asked me to come back. I sat there and my other team members took their positions. During that time, the troop behind us has given a message to our company commander that they have apprehended 2 miscreants. During the charge operation, grenades, pistols, etc. were recovered from the position of accused person standing on the top. When we inquired both of the apprehended miscreants, that the one miscreant, namely Alu, has told that the accused standing on the dock is the Tailai of NSCNK. Our officers told the accused Tailai is holding a big post and NSCNK. Thereafter, we took both of the miscreants to Longding and handed them over to the battalion headquarters. As I sustained bullet hit, my office concealed me that I am safe due to the bulletproof jackets. My BP jacket was taken away by our officer who was submitting the same to FSL examinations. During the charge operation, 1 pistol magazines with bullet, 4 hand grenades, 1 rubber stamps and receipt of collections money were received from the possession of accused person standing on the dock. The witness has verified the photographs of signature. He had verified his signatures at exhibit 2A to G. In cross, he said, as it was night and jungle, I have not seen the person who fired on me. 1 pistol, 1 magazine with 13 bullet, 3 detonator, 4 hand grenades, 1 rubber stamp of Raja Payo and money receipts from possession of accused person. As I was hit by bullet, I did not come to Longding. It was Naib Subedar Mr. Harpinder Singh who took the accused and seized material to Longding. He had also not stated that he was present or he had seen the recovery of arms and ammunition or explosive substances from the possession of the appellate. Now, PW3, he is Alu Wangsu, who was apprehended by the army personnel along with the appellant. So later he was dropped from the accused and he was made a prosecution witness. So what he had stated before this. My residence is at Longkhaw village. When I reside with my family, I have 1 kitchen and 1 room to reside. The accused person standing on the dock, namely Tailai Wansu, is from our village. I heard that he came on leave. On the date of incident during night, someone knocked my door calling by my name. I opened the door and seen accused Tailai Wansu. He told that he wished to stay for the night at my residence. I could not deny him. I prepared bed for him. Both of us slept. During midnight, defense personnel carried my home. They have started to hit the doors and command me to open the same. I opened the door. The defense personnel have apprehended me and accused Tailai Wansu at my home. They asked me to accompany them till the road and they told that they will allow me to come back home. But on the road, they have forcefully entered me in their vehicle with accused Tailai Wansu and our eyes were tied by clothes. There, one of the army personnel fired some bullets blindly. Thereafter, I was taken to Longding camp and handed over to the police. I was kept for about 6 days in custody till I was released on bail. The accused, when entered my home, told me that he came on leave. Accused Tyler is a member of NSCNK, and it is known to everyone in our village. I have seen the seized arm and ammunition alleged to have been seized from Tyler Vanshu at Longding camp when the defense personnel was taking photographs of the same. On the night, in cross, it says, on that night, accused Tyler came to
I
my
have read it.
after lunch.
No, I have read it.
Okay, so he had also not stated, because according to his versions, nothing was seized from him and they were apprehended from his home. Because the army personnel is saying that they had, after crossfire, they had apprehended, but as per him, it was seized, they were apprehended from their home and they were taken away, nothing was seized. And PW4 is the IO unit. May I read or after lunch? Why we continue?
How long will you take to complete?
Because I have to just make these things, only read only PW4 is there.
Oh,
Then after that, half an hour.
half an hour. I will complete it, I think.
Directly that can be completed. Only my contention is since PW4 is the IO. Yeah, I will. PW4 is the IO. May I release the positions. On 13/9/2019 at 21:40 hours, an FIR was filed by one Naib Subedar H. Singh. It is alleged that as per incredible information, a charge operation was carried on 13/9/2019 at around 00:45 hours. And during the operation, there was firefight with the incident in which one Jawan Sepoy, Satnam Singh, received a bullet hit on the bulletproof plate. During operation, one SS Colonel Tailai Wansu and SS Alu Wangnao tried to escape towards Nagaland, but they were apprehended and recovered one 9mm Glock pistols with magazines, 12 live ammunition, 13 live ammunitions, 4 numbers of hand grenades, 3 detonator, 1 rubber stamp of Rajapayo, extortion received paid from the possession of accused Tailai Wansu, on receipt of the FIR, the OC has registered Longding PS case number this under section 384 IPC, read with section 25(1)(b) A 27(2) Arms Act, read with section 9(b)(2) explosive substance and 10 and 13 of UAP Act, and endorsed the same to me for investigation. During investigation, I have visited the PO and draw sketch map as produced by the informant. I have arrested both of the FIR named accused, namely Tailai Wanchu and Alu Wangnao. Recorded their statement under 161 CRPC. I have also recorded the statement of informant as well as other witnesses. I have seized all the material produced by the informant with the accused person, including one bulletproof plate. During investigation, it is found that the accused Tailai Wanchu.
Okay, I read it.
Okay, Your Honor, this is the case. And then when he was again examined on 3rd, on another date, again, he had submitted his further examination was carried on. Here he had said that during investigation of 9mm pistol and ammunition, because after receipt of the FSL report, he was again examined. So he had exhibited the FSL report, then exhibited on in cross. I will come straight with to cross. Explosive and arms and ammunition are seized by me, which are produced by the informant at police station. Said explosives, arms and ammunition are recovered by the informant during operation at PO from possession of Tailai Wangsu. As per FIR, informant has recovered the material from the possession of accused. After a gunfight, accused tried to escape from the PO. During that time, accused was overpowered and explosive arms and ammunition was recovered from his possession. Accused person was apprehended at PO during operation and he was formally arrested after he was produced at PS. There was no independent witness during seizure of the explosive arms and ammunition. The bullet which allegedly hit BP plate of Satnam Singh was not sent for FSL examination. As per previous record, there are several other cases registered against accused Tailai Wansu for extortion. In money received, there is no name of accused is mentioned, but the stamp of Rajapayo, which was affixed in money received for extortion, was recovered from the possession of accused Tailai Wansu. Stamp of Rajapayo was recovered by the informant from the possession of the accused, which was produced at police stations. After conclusions of the prosecution's evidence, Your Honor, he was examined under 313. So, may I read that 313?
No required.
It is not required. Here there is a contradictions because none of the witness had said that the arms or whatever substance which is mentioned in the seizures was recovered from them, nor they had said that it was they were present and that was seized in presence of them. They have said that simply it was recovered by someone. We had produced this and accordingly police had seized on productions by the informant. Because informant had clearly denied because I was not present when it was recovered. Even PW2 also straightway denied that I was not the person who had recovered these things. So now when possession is in question, from which possession it was recovered and how it was recovered. Now may I come to seizure memo, Your Honor. It's in page number 68. Here, name of 2 seizure witnesses mentioned here, but prosecution have not examined them.
Yes, page number?
Page number 68.
Hmm. Yes, what regarding?
Here, 2 seizure witnesses, name of 2 seizure witnesses, but
2 seizure witnesses.
2 seizure witnesses
Not
there,
examined.
not examined by the prosecution.
Okay.
Second, they had not examined any expert who had stated that the seized arms and ammunitions are prohibited arms. That comes under 25(1)(a) and explosive substances, because until and unless there is an expert opinion, it cannot be presumed that the seized material are prohibited arms and explosive substances. And there is major contradictions between the statement of PW3, PW1, PW2, and PW4, Your Honor. Because PW4 has said that he had clearly stated on production. PW3, the version of PW3 is entirely different because there was no crossfire, nothing was done. They had simply apprehended, nothing was recovered from him. Only they had
PW3, PW4, and
PW1 and 2 and PW4. Yes.
not PW3.
3 is the totally different.
So only one witness stated about crossfiring.
Cross-firing 2 witnesses, 1 and 2. And 3 said that there was no cross-firing. They were apprehended from his home only. And with regard to extortions, no victim, nobody had stated that any money was demanded or put on threats. And accordingly, money was delivered to him. Only simply they say that money received but recovered. Even PW4 stated that nowhere the name of the appellant is mentioned, nor he had anything to do with it. Only the name of Rajapai or the stamp of Rajapai was mentioned. May I
So
come-
this person is in the jail or
He's in jail. He is from the date of arrest, he is in jail. He was not given bail also. May I come to section 84? What 384? Yes. Punishment for extortion, section 384. Whoever commit extortion shall be punished with imprisonment or either description for a term which may extend to 3 years or with fine or with both. And the extortion is defined under section 383. Extortion. Whoever intentionally put any person in fear of any injury to that person or to any other, and thereby dishonestly induce the person so put in fear to deliver to any persons, any property or valuable security or anything signed or sealed, which may be converted into a valuable security, committed extortions. But here, none of the witnesses appeared, or the prosecution has stated that the appellant had put anyone on threat or forced them to. So section 344 is not applicable. He was wrongly convicted under 384. Now I will come to section 25(1)(a) of the Arms Act.
Small a or a capital A?
capital. Whoever acquires has in his possessions or carries any prohibited arms or prohibited ammunitions in contravention of section 7 shall be punished with imprisonment for a term which shall not be less than 7 years, but which may extend to 14 years and shall also be liable to fine. Provide,
Prohibited arms is described in the definition.
yes, it is
They're
definition,
automatic,
automatic, but that has to be proved by an expert saying that this is an automatic rifle, so it comes under prohibited ammunition. But in this case, they had not examined any expert or the witnesses because PW 1 and 2 are army personnel. They had also not stated in their depositions that these are prohibited arms. So that is also, without that proof, I cannot be convicted under section 25(1)(a). And with regard to section 5 of the Explosive Substance Acts again, there is prosecution sanctions. Is there? Even in this case also no expert was examined by the prosecutions to determine that exactly the shift that were detonator, hand grenades and all. So until and unless that is expert is examined, I cannot be convicted for that also, because that has to be proved beyond reasonable doubt. Actually, the substance seized from, at least to have been seized from me, is a explosive substance. Here also, this, I cannot be convicted for this. And with these other two sections,
So once if he is released and acquitted, what will he do?
now he is almost, now he is, now insurgency is no more there. No insurgencies. Now people are becoming good. Even civil movement is there. So all are coming back to the civil society. So I don't think he will, because his father had already expired, his mother expired.
He is
So-
not functional now, not.
No,
upright.
now organizations are no more functional. So I don't think he will join again. So this is my prayer that since that the prosecution has not proved anything beyond reasonable doubt, so I may be acquitted and the judgment of sentence may be set aside and I may be set on liberty. Because from the date of arrest, I'm in jail. Still I'm in jail. That's
Yes, PP.
Lordship here, Lordship, it is convicted, Lordship, as per the Lordship, this records that this materials, Lordship, available, Lordship. This way is convicted under 384 and 25A, 1A, Arms Act, and as well as the explosive, Lordship. Because Lordship here, may see the Lordship, this prosecution witness 1, 2, and 4. They have clearly, Lordship, Lordship, kindly, Lordship, prosecution witness 1.
Yes.
Where they have Lordship stated that Lordship the stamp Lordship, the belonging which is they have used for the extortion Lordship, which the materials is found from the accused Lordship. Here in the statement Lordship, I have recommended my continuing officer Lordship in the order the line. I have recommended my continuing officer to hand over the accused person recover armed and explosive to the police station. Accordingly, I have taken the accused person to hospital for their medical checkup, and I have handed over the accused person along with armed and explosives to the officer in charge of the loading police station. Here, Lordship, it is clearly stated that these arms and all Lordship is recovered from him, Lordship. It is with him at that time, Lordship, when he is produced before the IO of the police station, Lordship. And Lordship, here in the prosecution witness 2, Lordship.
In which PW 1,
Lordship.
where he has stated I have recovered.
Lordship is the It's here, Lordship is a line 1, 2, 3, 7, 8, 9. After apprehension of the miscreant, the above arms and explosive. This line, Lordship, paragraph or third line or this seventh line, Lordship.
PW1, 7 line.
Lordship.
Seven.
Lordship, from here we can read Lordship. During the time of apprehension, one 9 mm Glock pistol made in the Austria with 1 magazine and 13 live rounds, 4 hand grenade, 3 detonator, 1 stamp of NSN organization. Stamp also is recovered, Lordship. From true by which they have they have the act of extortion among these villagers, Lordship. Lordship, this also is covered from the accused. And 1 receipt book also used for the money collection. After apprehension of the miscreant with above arms and explosive, they were taken to battalion headquarters at Pongchau and thereafter they are taken to our headquarters Longding. I was commanded by my controlling officer to hand over the accused person with recovered arm and explosive to the police station. And Lordship, in prosecution witness number 2 also, it is clearly stated that when he inquired about the apprehended miscreant, then 1 miscreant, namely Alu, has told that accused standing on a dock is Talai of NSCNK. Our officer told that accused Talai is holding a big post in NSCNK. Thereafter, we took both of the miscreant to Longding and handed them over to our battalion headquarters. Here also his accused name is reflected, Lordship, and in the cross also, Lordship, when it was examined in the cross, it was stated that as it was night and jungle, I have not seen the person who fired on me. 1 pistol, 1 magazine with 13 bullets, 3 detonators, 4 hand grenades, 1 rubber stamp or ranapeno, and money received were seized from the possession of accused person. Here also in the cross also, Lordship, the accused person was seen and his this all the material, this bullets and all recovered from the accused person, Lordship. And Lordship, PW4 also. My Lordship. On 13/9/2019 at 21:40 hours, an FIR was filed by 1 Naib Subedar S. Singh. It is alleged that as per the incredible information, a search operation was carried on 13/9/2019 at around 12:45 hours, and during the operation there was firefight with the insurgent in which 1 Jawan Sepoy Satnam Singh received a bullet hit on the bulletproof plate. During operation 1, SS Colonel Talai Wangso, this is the present accused, Lordship, this convict person, and SSCPL Alua Wangnao tried to escape towards Nagaland, but they were apprehended and recovered. Lordship, here also recovered 1 9 mm Glock G pistol with magazine, 19 live ammunition, 4 number of hand grenade and 3 detonators, 1 rubber stamp Rajapio extortion receipt paid, Lordship. Extortion receipt paid from the possession of accused Talai Wangsu. On receipt of the FIR, the OCPS has registered loading PS number. This is the short, Lordship, that after the recovery, Lordship, these numbers of, Lordship, these sections were imposed upon him and endorsed the same to me for the investigation. Lordship, there's sufficient materials, Lordship, against the accused, Lordship. And Lordship, on the 313 also, Lordship, the accused, Lordship, could not explain to how this process, the materials recovered from him, Lordship. He could not say anything in the 313 also.
All right.
So, Lordship, this rightly the conviction was made out against the accused, so he's now serving in jail, Lordship, as per this. So this appeal should not be, Lordship.
Hard.
Here, Your
Mr.
Honor, I am submitting 2 citations with regard to
Yes.
313 and prohibited arms. So
Have
I'm,
you mentioned a paragraph?
yes, I have mentioned.
Alright, by defense, by appellant.
Apple.
I also got this prohibited arms.
Yes.
I got one judgment, but I forgot where I left it. About prohibited arms and
Prohibited arms.
non-prohibited arms.
Because automatic is a prohibited, but that has to be ascertained by an expert. Or even if here army personnel are expert in using arms, had they been stated, this, these are the things that are prohibited, then I could have been convicted for this, but they had not said anything with
Anything
regard to
about prohibited.
prohibited arms.
And regarding the seizure witness lordship, because the witnesses are from lordship from their side also only lordship, there is not immaterial lordship. Because independent witness is not there lordship. And we could not say lordship if independent witness is not there, then seizure could not be made out lordship. So everything is against the lordship, convict person lordship. So as per the lordship, the material available, all the lordship, their statement lordship, they all the
But
content.
that person in this photograph, he appears to be a tiny person,
No, not that.
small in size.
No.
Huh?
No, not.
That doesn't matter lordship.
Not
Actually,
that.
Tall. Huh?
He is tall. Taller.
Oh, but
Tiny one is that related to
Other
ML
one.
and the other one. He's from NSC and IM.
নামটো ওপৰত লিখি দিব হা, তেওঁলোকৰ নাম চব লিখি দিব। Hard Mr.
DK
Devi,
Dev.
D. Devi, learned counsel for the petitioner or appellant, and Miss Lakshmi Hage, learned additional PP for the state of Arunachal Pradesh. It would be my devoted. Reserve for judgment. Hard arguments by both the sides, reserve for judgment. It will be devoted in my.
God bless.
So it's concluded before half an hour.
It's not much, it's only for witness.
No point getting